Gentleman from Arizona, Mr. Gosarf. Oh, let's go ahead and go to the gentleman from South Carolina, Mr. Mulvaney first.
Thank the gentleman. Director Comey, earlier today you heard a long list of statements that Mrs. Clinton has made previously, both to the public and to Congress, that were not factually accurate. I think you went down the whole long list. When she met with you folks on Saturday last week, I take it she didn't say the same things at that interview?
I'm not equipped sitting here without the 302 in front of me to answer in that broad brush.
But it's your testimony.
But I have no basis. We do not have a basis for concluding she lied to the FBI.
Gotcha. Did anybody ask her on Saturday why she told y'all one thing and told us another?
I don't know as I sit here. I mean, I'll figure that out.
Would that have been of interest to you in helping to establish intent?
It could have been, sure.
More importantly, I think, did anybody ask her why she set up the email system as she did in the first place?
Yes.
And the answer was convenience?
Yeah, it was already there. It was a system her husband had, and so she just jumped onto it.
Were you aware that just earlier this week her assistant actually said it was for an entirely different reason? It was to keep emails from being accessible, and that it was for a concealment purpose? Uma Abedin was asked in her deposition why it was set up, and it was said to keep her personal emails from being accessible. Question to whom? To anybody? Were you aware of that testimony?
Generally, yes.
Okay, so here's sort of the summary I take from what we've done today, which is that over the course of the entire system, what she did, she intentionally set up a system. According to your testimony, your findings, she was careless regarding its technical security. I think you said that even a basic free account, a Gmail account, had better security than she had. And she did that, according to her own staffer's sworn deposition, for the purpose of preventing access to those emails. As a result of this, she exposed top-secret information to potential hack by foreign actors. You've seen the emails. We have not. I think you said earlier that the emails could be of the sort that would put national security at risk, and I think we had testimony earlier that got you to acknowledge that it might even put our agents overseas at risk.
Yeah, I don't think I agree with that, but it's still important.
Okay. All right. She kept all of that secret until after she left the State Department. She lied about it, or at least made untrue statements about it, after it finally came to light. She thereafter ordered the destruction of evidence that was destroyed so thoroughly that you folks could not do an adequate recovery. Yet she receives no criminal penalty. So I guess this is my question to you. Are we to assume, as we sit here today, that if the next president of the United States does the exact same thing on the day he or she is sworn into office, sets up a private email service for the purpose of concealing information from the public or from anybody, that as a result of that potentially exposes national security level information to our enemies, lies about it, and then destroys the evidence during an investigation, that there'll be no criminal charges, if you're the FBI director, against that person?
Yeah, that's not a question the FBI director should answer. I mean,
no, I'm asking you if she does the exact same thing as president as she's done today, your result would be the exact same as it was 48 hours ago. There'd be no criminal findings, right?
If the facts were exactly the same?
Right.
And the law was exactly the same?
Right.
Yeah, the result would be the same.
And I guess under the theory that if the law is to be equally applied to everybody, that if a White House staffer does the exact same thing for the exact same purpose and exposes the exact same risks, that there'll be no criminal action against that person. That could be, as you've mentioned, administrative penalties. There are no administrative penalties, as I understand it, by the way, against the president, correct?
I don't think so, but I'm not a
I don't think there are either.
scholar.
I don't think you can take away the president's top security clearance, and I'm pretty sure you can't fire the president because we've tried. Not only would a staffer not have any criminal charges brought against them, but I suppose a summer intern could do the exact same thing under the theory that we're going to apply the law equally regardless of who the people are. My question to you is this, and it's not a legal question. I guess it's a common sense, ordinary question that folks are asking me. From a national security standpoint, somebody who used to lecture on that, does that bother you?
The mishandling of classified information bothers me no matter what circumstance it occurs in, because it has national security implications.
Does it bother you that the precedent that you are setting today may well lead to a circumstance where our top secret information continues to be exposed to our potential enemies?
No, in this sense. The precedent that I'm setting today is my absolute best effort to treat people fairly without regard to who they are. If that continues to be the record of the FBI and the Justice Department, that's what it should be. The rest of the implications in your question are beyond that. They're important, but they're not for the FBI to answer. We should aspire to be apolitical, facts and the law, treat Joe the same as Sally, as Secretary so-and-so. That's my goal.
If you would come to a different decision, by the way, I tend to agree everything you just said. If you would come to a different decision, do you think that would have a different precedential value that would keep our information more safe?
If we decided to recommend criminal charges here? I don't know. That's a good question. I don't know. I could argue it both ways. I guess I'm a lawyer. I can argue everything both ways, but I could argue that both ways.
Thank you, Director Comey. Thank you, Mr. Chairman.
Thank the gentleman. Now recognize the gentleman from Arizona, Mr. Gosar, for 5 minutes.
Thanks, Mr. Chairman. Thank you, Mr. Comey, for being here. My colleague alluded to Brian Pagliano, the IT advisor, and were you made aware of the deal of immunity with him?
I am aware.
Now that Attorney General Lynch has stated that there will be no charges, there's many that suspect that that he failed to answer questions in his congressional deposition, that he had something to hide. Why did your investigators at the DOJ decide it was necessary to offer Mr. Pagliano immunity?
As I said in response to the earlier question, I need to be more thoughtful about what I say about an immunity deal in public. Maybe totally fine. I just don't want to screw up because we're doing this so quickly.
Okay.
In general, I can answer, because I've done it many times as a prosecutor. You make a grant of immunity in order to get information that you don't think you could get otherwise.
But you know that there may be something there in hindsight, right? You're looking ahead because of the pertinent information this person possesses.
Right. You believe they have relevant information to the investigation.
So did the investigators draft an interview report known as a 302 with Mr. Pagliano?
Yes.
Given the importance of this case, will you commit to voluntarily disclosing the 302s for review of Brian Pagliano and other witnesses interviewed as part of your investigation?
I'll commit to giving you everything I can possibly give you under the law and to doing it as quickly as possible. That said, then that means I got to go back and sort it out. For example, the 302 of Secretary Clinton is classified at the TSSCI level, so we got to sort through all that, but we'll do it quickly.
Yeah, I know you've done this because you've done this for Lois Lerner and other cases, so we would expect that. Now, Director Comey, Hillary Clinton testified before Congress and told the American people multiple times that she never emailed any classified information to anyone on her private email servers. Your investigation revealed 110 of Clinton's emails and 52 email chains contain classified information. Clinton told the American people, and I quote, "The laws and regulations in effect when I was Secretary of State allowed me to use my email for work. This is undisputed," end of quote. Your investigation revealed that that also wasn't true. Clinton claims she turned over all her work-related emails. Your investigation revealed that this wasn't also true. Clinton claimed that there was no security breaches and her private servers had numerous safeguards. Your investigation revealed 8 email chains on Clinton's private servers containing top-secret information, and that it was possible hostile actors gained access to sensitive information. Further, multiple people she emailed with regularity were hacked by hostile actors, and her private servers were less secure than a Gmail account, making a security breach all the more likely. Director Comey, it's a federal crime, as you know, to mishandle classified information in a grossly negligent way, and you stated Clinton and her colleagues were extremely careless. Clinton has publicly stated she was well aware of the classification requirements, yet she broke the law anyway. Multiple people have been prosecuted for less, and there is a growing trend of abuses in senior-level employees. The only difference between her and others is her total resistance to acknowledge her irresponsible behavior that jeopardized our national security and the American people. I think you should have recommended Clinton be prosecuted under Section 793 or Section 1024 of Title 18. If not, who? If not now, when? Your recommendation deprived the American people of the opportunity for justice in this matter. There shouldn't be a double standards for the Clintons, and they shouldn't be above the law. With that, I'm going to yield the rest of my time to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Dr. Gosar. Director Comey, I want to go back to the issue of intent for just a second. We can disagree on whether or not it's an element of the offense. Let's assume for the sake of argument that you're right and I'm wrong and that it is an element of the offense. Secretary Clinton said that she was, quote, well aware of classification requirements. Those are her words, not mine and not yours. So if she were, quote, well aware of classification requirements, how did that impact your analysis of her intent? Because I've heard you this morning describe her as being less than sophisticated. She disagrees with that.
Well, I was talking about technical sophistication. The question is, I would hope everybody who works in the government is aware of classification requirements. The question then is, if you mishandled classified information, when you did that thing, did you know you were doing something that was unlawful? That's the intent question.
All right. Well, you and I are going to have to get together some other time and discuss all the people we prosecuted who were unaware that they were breaking the law. There are lots of really dumb defendants out there who don't know that what they're doing is against the law. But let's go with what you say.
I disagree. You may have prosecuted a lot of those folks. I did not prosecute a lot of those folks.
I was a gutter prosecutor and you were a white-collar prosecutor. Trust me, there are lots of people who don't know you can't kill other people. Let me ask you this. On the issue of intent, you say it was convenience, okay? You're a really smart lawyer. If it were convenience, Director, she wouldn't have waited 2 years to return the documents, and she wouldn't have deleted them 4 years after they were created. So you can't really believe that her intent was convenience when she never turned them over until Congress started asking for them, could you?
Yeah, my focus, and I hope I made this clear, my focus is on what was the thinking around the classified information. I mean, it's relevant why the system was set up and the thinking there, but she didn't, I don't understand her to be saying, well, I think I've said it already, but that's my focus.
So I know I'm out of time, but it just strikes me you are reading a specific intent element into a gross negligence statute, not even general intent.
Gentleman's
a
time.
Specific intent
Gentleman's time has
element.
expired.
Yeah. I'm sorry.
Go, the director can answer.
I enjoy talking with him. The question you got to ask is, so why is it that the Department of Justice, since 1917, has not used that gross negligence statute, but charging it once in an espionage case? And whether their decision was smart or not, that is the record of fairness. And so you have to decide, do I treat this person against that record? And if I do, is that a fair thing to do? Even if you're not worried about the constitutionality of it. And my judgment is no reasonable prosecutor would do that. That would be celebrity hunting. That would be treating this person differently than John Doe.
Director, I want to follow up on that. Why did you do what you did? You know, my interpretation of what the FBI is supposed to be doing is come to a determination of the facts and then turn it over to a prosecutor. You were a prosecutor, but you're not a prosecutor now.
Right.
It is unprecedented that an FBI director gave the type of press conference that he did and took a position that an unreasonable prosecutor would only take this case forward. Why did you do that?
Yeah. It's a great question. Everything I did would have been done privately in the normal course. We have great conversations in the FBI and prosecutors. We make recommendations. We argue back and forth. What I decided to do was offer transparency to the American people about the whys of that, what I was going to do, because I thought that was very, very important for their confidence in the system of justice. And within that, their confidence in the FBI. And I was very concerned, if I didn't show that transparency, that in that lack of transparency, people would say, geez, what's going on here? Something seems squirrely here. And so I said, I will do something unprecedented, because I think this is an unprecedented situation. Now, the next director, who is criminally investigating one of the two candidates for president, may find him or herself bound by my precedent. Okay, so if that happens in the next 100 years, they'll have to deal with what I did. So I decided it was worth doing.
Mr. Cummings.